While farmers disclose a great deal of information to the USDA to be able to participate in federal programs, concerns often loom regarding the degree of privacy of their records. Roger McEowen with the Washburn School of Law joins us now with a closer look. Roger, appreciate you being with us today. Bring us up to speed on the Freedom of Information Act and how that works.
Well, good to be with you, Tammy. This is a law that's been on the books a long time, since 1967. Congress enacted it then, and it was with the express purpose of trying to make government agencies more transparent. And I think a lot of farmers are concerned, of course, with the information that they share with USDA in order to participate in federal farm programs. And so the question is, how does the law protect that? Or can somebody access their information that might be farm-specific and location-specific and number-specific from a Freedom of Information Act request?
Now, are there any exemptions when it comes to agriculture?
There are. Under the statute, there are 9 exemptions. I think 3 of them, 2 of them in particular, are important for ag, but 3 of them can be utilized by ag. One is when there's an underlying statute that protects the information, and another one says when it's personnel or medical files and similar files, when the disclosure of the information would constitute an unwarranted invasion of personal privacy. And then the third one, it exempts geological information and data, including maps concerning wells. So I think those 3 are the big ones that agriculture can use to protect data from being disclosed by USDA from a FOIA request.
Have you heard about any specific stories or examples that you can share with us?
Yeah, there was a big case just late last month when we had a company that's in the business of collecting and analyzing ag data from various sources, including the federal government, that made 7 FOIA requests to the USDA for specific records. And they wanted farm-specific information, track numbers, customer numbers that the USDA had. And the court upheld the USDA's refusal to disclose that information, saying that if you disclose the farm and the track numbers, that's geospatial information. It also would be an unwarranted invasion of personal privacy, and we're not going to do that. And so the trial court in D.C. upheld USDA's refusal to release that information. So I think that's a welcome decision by many farmers, because it does protect that data that a lot of farmers worry about, especially livestock operations.
Absolutely, because that's a lot of information and very personal. So what's the big takeaway for farmers?
Well, the big takeaway is, while we're always concerned about the information that the government gets from us for participating in farm programs, that's kind of the trade-off. There are some of these exemptions built into law that will protect that data from being disclosed to groups and other individuals that may not appreciate agriculture the way that we do, and I think that's welcome news.
Definitely is. That's Roger McEowen with the Washburn School of Law. Appreciate your time and information today.